trial, and we should be able to resolve this matter, Your Honor.
Okay, so this case has been pending since September. I will grant this adjournment, but I would say this would be the last adjournment I'm going to grant at this point to discuss plea options. So if we don't have an agreement at the next hearing, we set it for trial. I will adjourn this then to January, go with January 14th at 8:15.
Thank you, Your Honor.
And Ms. Underwood, would you do that stipulation in order for?
I would be happy to do that with Mr. Sneed's permission.
Yes, thank you.
And Your Honor, just in terms, do we have fingerprints and everything for Mr. Morgan?
I have an advice of rights form that is in the file. I do not have fingerprints yet. I believe that we sent a copy of the order for prints to the MDOC facility, and we're trying to see if they can do his prints there.
Thank you, Your Honor.
Right. All right, so Mr. Morgan, you are all set for today.
Thank you.
Thank you. This goes in the works. Okay, the gentleman at the MDOC facility, can you tell me your name?
Jonathan Kessner.
Okay. Let's see. All right, Mr. Ketzner, we're still waiting for your attorney, Mr. Dagner-Rongosian, to get logged in. So I'm going to put you back in the waiting room until he gets here.
My attorney, who?
Mr. Dagner-Rongosian?
Who is that?
I'm sorry, is that not your attorney?
No, it's supposed to be Glazier.
Oh, I'm sorry. Mr. Glazier is not here today. Mr. Dagner-Rongosian is just covering for him today.
Okay.
So I'm going to, again, I'll put you back out in the waiting room until he gets here.
Okay.
Call for Mr. Okay, Ms. Underwood, we have Jennifer Berger is here in the courtroom. Do you need to speak to her?
Yes, Your Honor. Thank you.
Okay, Ms. Berger. Yeah, if you'll step outside of the iPad.
Could we have stayed in the Hi.
Okay, give me just a second. I'll put you in a breakout session with Ms. Underwood. Mr. Murphy, do you need a breakout session with Mr. Morris?
Bucko, please, Your Honor.
1 second. Mr. Morris, if you're there, I need you to unmute your device.
Yes, sir.
Okay, Mr. Morris, I'm going to put you in a breakout session with your attorney in, if you give me just a moment here.
Yes, sir.
Okay, and Ms. Devon, I have Ms. Flores here. Do you need to speak to her?
No, Your Honor, we're ready.
Okay, I'm bringing her into the meeting right now.
Thank you.
Okay, Ms. Flores, can you hear me?
Yes, I can.
Okay. This is file 25-22462-FH, 25-22463-FH, and 25-22464-FH. People versus Latasha Noni Flores. We are here today for a pretrial conference in these cases. We're proceeding today by video conference. First, can I have the attorneys place their appearances on the record, beginning with Mr. Sneed.
Isaac Sneed for the people.
Katerina Dumont for Ms. Flores.
And Miss, you are Latasha Noni Flores. Ms. Flores, are you there?
Yes,
You are Latasha
I
Noni
am.
Flores?
For some, it keeps on saying unstable network.
Okay,
Yes, I am.
I'm going to turn off your video, and sometimes that helps things.
Okay. Kind of
All right.
moving my laptop around too. There we go.
Okay, Ms. Dumont, where do we stand with Ms. Flores's cases today?
Your Honor, I provided the court with signed advice of rights and plea offer. The offer is to plead to count 1 in 25-22464-FH. No objection to 7411. The rest of her charges would be dismissed, was the agreement I had with prosecution.
Mr. Sneed, is that a complete and accurate statement of the agreement?
Yes, it is, Your Honor.
Okay. Ms. Flores, will you raise your right hand? Let me know when you have it raised, please.
Okay.
Do you swear or affirm to tell the truth, the whole truth, and nothing but the truth under penalty for perjury?
Yes, I do.
And again, you are Latasha Noni Flores, is that correct?
Yes.
Ms. Flores, you've heard the statement of your attorney and the prosecuting attorney. Is it your intention to plead guilty today in file 25-2464-FH to count 1 controlled substance, possession, cocaine, heroin, or another narcotic less than 25 grams?
Yes.
Do you understand that the maximum possible penalty for that offense is up to 4 years in prison and or a $25,000 fine?
Yes.
Are you satisfied with Ms. Dumont and the advice that she's given you?
Yes, I am.
Neither the prosecutor, defendant, or anyone acting on the defendant's behalf has discussed a possible sentence with the court. Is that correct, Mr. Sneed?
Yes, it is, Your Honor.
Ms. Dumont?
Yes, Your Honor.
Is that also your understanding, Ms. Flores?
Yes, it is.
If a guilty plea is accepted, there'll be no trial. That means you're giving up the rights that you would have had at trial. I'm going to explain those rights to you now to make sure that you understand them. If you do have the right to a speedy public trial by jury, you could ask for a non-jury trial, and if the prosecutor and the court agreed, you could have a non-jury trial. You have the right to be presumed innocent until proven guilty beyond a reasonable doubt. You have the right to have the prosecuting attorney prove beyond a reasonable doubt that you are guilty, and you do not have to prove anything. You have the right to be present at your trial, to have the witnesses against you appear at your trial, and to ask the witnesses questions. You have the right to have the court order any witnesses you have for your defense to appear at your trial. You have the right to remain silent during your trial and not have that silence used against you. However, you also have the right to testify at your trial if you wanted to testify. You understand, Ms. Flores, that if your plea is accepted, you may be giving up the right to appeal issues that would otherwise be appealable if you were convicted at a trial.
Yes, I do.
You also understand that any appeal from the conviction and sentence pursuant to your plea would be by application for leave to appeal and not by right.
Correct.
If you are not a citizen of the United States of America, conviction of a crime can result in deportation, exclusion from admission to the United States of America, or denial of naturalization. Do you have any questions about any of the rights I've explained to you?
I do not.
Do you understand that you're giving those rights up?
I do.
How do you plead then to the charge that on or about September 30, 2025 in the city of Adrian, County of Lenawee, state of Michigan, that you did commit the offense of controlled substances, possession of fentanyl of less than 25 grams?
I am guilty of that.
Has anybody made any threats or promises to you to induce you to plead guilty to that charge?
No, Your Honor.
Do you understand that if I accept your plea, you're giving up any and all claims that that plea was given as a result of threats or promises that were not disclosed to the court on the record today, or that it was not your own choice to enter the plea?
I do.
Is the prosecutor or defense counsel aware of any promises, threats, or inducements other than the plea bargain to induce Ms. Flores to plead guilty today?
No, Your Honor.
Your Honor.
Ms. Flores, has your attorney promised you any particular sentence or estimated what your sentence would be?
No, not as of now.
Okay, if your plea is accepted and you engage in misconduct, the court's not bound by any sentencing agreement or evaluation. Misconduct includes but is not limited to absconding or failing to appear at sentencing, violating bond conditions, violating the terms of any plea or sentence agreement, or otherwise failing to comply with an order of the court pending sentencing. Do you understand that?
I do understand.
Is it your own choice to plead guilty today?
Yes, it is.
Ms. Dumont, would you like to establish the factual basis?
Yes, Your Honor. Ms. Flores, on or about September 30th of 2025, were you in the city of Adrian, County of Lenawee, state of Michigan?
Yes.
And did you come in contact with police on that date?
Yes, I did.
And on your person, they found a clear plastic baggie with some substance in it?
Yes.
And would you agree that when they tested that substance, it came back at 0.14 grams of fentanyl?
Yes.
Okay. And you had no legal reason to possess that at that point. Is that right?
That's right.
Thank you. I'm satisfied if the court and prosecution.
Is any of the people satisfied?
Yes, thank you.
Has the court complied with MCR 6.302 B, C, and D, Mr. Sneed?
Yes, Your Honor.
Ms. Dumont?
Yes, Your Honor.
All right, I'll accept the plea then. It's been given understandably, voluntarily, and accurately. Ms. Flores has had full knowledge of her rights and she's had competent counsel. The court has not made any agreement regarding the possibility of a plea or sentence in this case with the prosecutor, defense attorney, or defendant for anyone acting in interest of being with them. I will refer this matter to the probation department for a pre-sentence investigation and set sentencing for January 22nd at 8:15 a.m.
Thank you.
Ms. Flores, someone from the probation department is going to be in touch with you to do a pre-sentence investigation interview. When you do that interview, please be truthful about this offense and about your background.
Okay. And I'm sorry. Right, just so I can write this down, you said January, what was the date and time again?
22nd at 8:15 a.m.
Oh, Lord. Okay.
All right.
And so the court will be getting a hold of me.
Someone from the probation
probation will?
department. I also right now, I'm going to put you in a breakout session with Mr. Stevenson from the probation department, and he's going to collect your contact information and give you some instructions on what to do next.
Okay, sounds good. Thank you so much.
Thank you.
Okay, Ms. Demont, do you want to be in that breakout session as well?
No, Your Honor, I have to go to another court. But
Okay, so 1 second, Ms. Flores.
Thank you.
Okay, Mr. Noe, are you ready to proceed with Mr. Maples?
I certainly am.
Okay. So this is file 23-2197-FC. People of the state of Michigan versus Stephen Maples. We are here today for a pretrial conference. In this case, we're proceeding by video conference. First, can I have the attorney's place their appearance on the record, beginning with Ms. Arnold.
Allison Arnold for the people.
Good morning, Your Honor. Charles Noe appearing on behalf of Mr. Maples.
Okay, and Mr. Noe, where do we stand with Mr. Maples' situation today?
Your Honor, I can very gladly tell the court that I have had several updates from my forensic evaluator. I am in receipt of a report, which I need to review with my client. Once I've had a chance to review that with my client, if I find it is appropriate, I'll provide that to Ms. Arnold. And I would ask for keep our trial dates, everything as is. If we could set another pre-trial, maybe sometime in January. I looked at my calendar. I was thinking January 21st. So that works for the court and Ms. Arnold to make sure we have our thumb on this and make sure there's progress.
All right, Ms. Arnold, anything you would like to address?
No, my only request with Mr. Noe and his client is if we're going to use information from this expert witness, that they get me a copy of that letter, hopefully by the end of the year at the latest, so I have time to talk to an expert potentially before that next pretrial and make sure that we can still keep our trial dates.
That's entirely reasonable.
All right, so we'll set a pretrial for January 21st at 8:15 a.m. And Mr. Noe, if you're going to use that expert, then that information, the report needs to be disclosed to Ms. Arnold by December 31st.
You want me to put together that as a step or as an order? How do you want me to put that together, Judge?
I think a stipulation is probably okay.
I would so stipulate.
Okay.
That's fine.
All right. So you want to put that in a stipulation?
I'll build in the pretrial the 21st, January 21st, and that stipulation for the expert disclosure into one step if that works for the Ms. Arnold and for the court.
Yeah, that's fine.
Okay. Ms. Arnold, may I send that with your permission, please?
Certainly.
All right. Is there anything else we need to address with Mr. Maples' case today?
No, thank you, Your Honor.
No, Your Honor. Thank you.
All right. Mr. Maples, you can let the officer with you know that you're done with court for today.
That's yours, sir.
Okay. Ms. Underwood, are you ready to proceed with Ms. Berger?
Yes, Your Honor. Thank you.
Ms. Berger, you want to come forward, please? This is file 24-22060-FH, People of the State of Michigan versus Jennifer Marie Berger. We're here today for a probation violation. We are proceeding today partially in person and partially by video conference. Ms. Underwood, would you like to place your appearance on the record?
Rhonda Underwood from Ms. Berger this morning, Your Honor. Thank you.
All right. And Ms., you are Jennifer Marie Berger, correct?
Correct.
I'm
All right.
sorry, you
Yeah.
broke up a little bit, Your Honor.
Ms. Underwood, where do we stand with Ms. Berger's case today?
Thank you. Ms. Berger has the case in district court, which has a court date of January 6th, Your Honor. And so we would be asking for an adjournment till after that.
Okay, let's go with January 14th
Thank you, Your Honor.
at 8:15 a.m.
Thank you.
So Ms. Berger, your next date will be January 14th at 8:15 a.m.
All right, thank you very
Thank
much.
you. Who's next? And Ms. Underwood, I have Mr. Collar is here in the courtroom. Do you need to speak to him?
Yes, please.
Okay, so Mr. Collar, to step out to the iPad, please.
Your house, you got covered for substance abuse.
Okay, Mr. Murphy, you ready to proceed with Mr. Morris?
Yes, Your Honor.
Okay, this is file 25-22334-FH, People of the State of Michigan versus Robert Scott Morris Sr. We are here today for a final pretrial hearing in this case, and we are proceeding today by video conference. First, can I have the attorneys place their appearance on the record, beginning with Mr. Bayanetto.
Alex Bayanetto for the people.
Matthew Murphy appearing on behalf of Mr. Morris.
And Mr. Morris, I'm going to send you a request to unmute. And you are Robert Scott Morris Sr., correct?
Yes, sir.
Have a seat. Let me know if you have any problem.
All right, Mr. Murphy, where do we stand with Mr. Morris's case today?
Your Honor, the people have offered for Mr. Morris to plead guilty to count 1, possession of cocaine, with no habitual offender status, and with agreement for Mr. Morris to serve probation moving forward after he's completed his rehab time in rehab. I'm not quite sure how long he has left for that. Sometime in January, I believe, or late, early January, I believe. But Mr. Morris did want to go ahead and take that offer. I am trying to send over to the court a signed offer, that plea offer, as well as signed advice of rights. So again, at this time, he wishes to plead guilty to possession of controlled substance, cocaine.
Okay, Mr. Bayanetto, is that a complete and accurate statement of the plea agreement?
It is, Your Honor.
And Mr. Murphy, you said you have a signed advice of rights form?
Yeah, Your Honor. I'm trying to have my office send over a copy of that, or send that over.
Okay. Mr. Morris, would you raise your right hand, please? Do you swear or affirm to tell the truth, the whole truth, and nothing but the truth under penalty for perjury?
Yes, sir.
And you are Robert Scott Morris, Sr.?
Yes, sir.
Mr. Morris, you've heard the statement of your attorney and the prosecuting attorneys that your intention to plead guilty today to possession of cocaine of less than 25 grams.
Yes, sir.
You understand that the maximum possible penalty for that offense is up to 4 years in prison and or a $25,000 fine.
Yes, sir.
Neither the prosecutor or defense attorney or anyone acting on the defendant's behalf has discussed possible sentence with the court. Is that correct, Mr. Banetto?
That's correct, Your Honor.
Mr. Murphy?
That's correct, Your Honor.
Is that also your understanding, Mr. Morris?
Yes, sir.
If the guilty plea is accepted, there'll be no trial. That means you're giving up the rights that you would have had at trial. I'm going to explain those rights to you now to make sure that you understand them. You have the right to a speedy public trial by jury. You could ask for a non-jury trial, and if the prosecutor and the court agreed, you could have a non-jury trial. You have the right to be presumed innocent until proven guilty beyond a reasonable doubt. You have the right to have the prosecuting attorney prove beyond a reasonable doubt that you are guilty, and you do not have to prove anything. You have the right to be present at your trial, to have the witnesses against you appear at your trial, and to ask those witnesses questions. You have the right to have the court order any witnesses you have for your defense to appear at your trial. You have the right to remain silent during your trial and not have that silence used against you. However, you also have the right to testify at your trial if you wanted to testify. Do you understand, Mr. Morris, that if your plea is accepted, you may be giving up the right to appeal issues that would otherwise be appealable if you were convicted at a trial?
Yes, sir.
Do you also understand that any appeal from the conviction and sentence pursuant to your plea would be by application for leave to appeal and not by right?
Yes, sir.
If you are not a citizen of the United States of America, conviction of a crime can result in deportation, exclusion from admission to the United States of America, or denial of naturalization. Do you have any questions about any of those rights?
No, sir, I don't.
Do you understand that you're giving those rights up?
Yes, sir.
How do you plead then to the charge that on or about April 28th, 2025, in the city of Adrian, county of Lenawee, state of Michigan, that you did commit the offense of possession of cocaine of less than 25 grams?
Yes, sir. I plead guilty.
Has anybody made any threats or promises to you in order to induce you to plead guilty to that charge?
No, sir.
Do you understand that if I accept your plea, you'll be giving up any and all claims that your plea is given as a result of threats or promises that were not disclosed to the court on the record today, or that it was not your own choice to enter the plea?
Yes, sir.
Is the prosecutor or defense counsel aware of any promises, threats, or inducements other than the plea bargain to induce Mr. Morris to plead guilty today?
No, Your Honor.
Your Honor.
Mr. Morris, has your attorney promised you any particular sentence or estimated what your sentence would be?
No, sir.
If your plea is accepted and you engage in misconduct, the court's not bound by any sentencing agreement or evaluation. Misconduct includes, but is not limited to, absconding or failing to appear at sentencing, violating bond conditions, violating the terms of any plea or sentence agreement, or otherwise failing to comply with an order of the court pending sentencing. Do you understand that?
Yes, sir.
Is it your own choice to plead guilty today?
Yes, sir.
Sir Murphy, would you like to establish a factual basis?
Yes, Your Honor. Thank you. Mr. Morris, were you indeed in the city of Adrian, the county of Lenawee, state of Michigan on April 28th of 2025 this year?
Yes, sir.
Okay, and on that date, did you indeed have in your possession cocaine?
Yes, sir.
Did you know that it was cocaine?
Yes, sir.
Did you have any legal reason to possess that cocaine?
No, sir.
Your Honor, I believe we satisfied the factual basis.
Sir Banetto, are the people satisfied?
Yes, Your Honor.
Has the court complied with MCR 6.302 B, C, and D, Mr. Banetto?
It has, Your Honor.
Mr. Murphy?
Yes, Your Honor.
All right, I'll accept the plea then. It's been given understandably, voluntarily, and accurately. Mr. Morris has had full knowledge of his rights to have competent counsel. Court's not made any agreement regarding the possibility of a plea or sentence in this case with the prosecutor, defense attorney, defendant, or anyone acting in the interest of any of them. I will refer this matter to probation department for a pre-sentence investigation and set sentencing for January 30th at 8:15 a.m. Mr. Moore, someone from the probation department is going to be in touch with you to do a pre-sentence investigation interview. When you do that interview, please be truthful about this offense and about your background.
Yes, sir.
And if you'll give me just a moment, I'm going to put you in a breakout session with Mr. Stevenson from the probation department. He's going to collect your contact information and give you some instructions.
Okay. Yes, sir.
Okay, Ms. Underwood, are you ready to proceed with Mr. Collar?
Yes, Your Honor.
And Mr. Dagger-Margosian, I do have Mr. Kensner here from the MDOC facility. Are you going to need to talk to him?
I would like to. I'm covering for Mr. Glazer, but I'd like to speak with him, please.
Okay. Mr. Kensner, I'm going to put you in a breakout session with Mr. Dagger-Margosian. If you give me just a moment.
Yes, sir.
Okay, this is file 25-22490-FH, People of the State of Michigan versus Brian Cody Collar. We are here today for an arraignment in this case, and we are proceeding today partially in person and partially by video conference. First, can I have the attorneys place their appearance on the record, beginning with Mr. Sneed.
Isaac Sneed for the people.
Ron Underwood for Mr. Collar this morning, Your Honor.
And sir, you are Brian Cody Collar?
Yes, sir.
Ms. Underwood, does Mr. Collar wish to have the information read this morning?
We would waive the reading of the information, acknowledge its receipt and the receipt of the witness list, and request for discovery. We would ask the court to enter a not guilty plea on Mr. Collar's behalf and set this matter for a pretrial.
All right, I'll enter a not guilty plea for Mr. Collar, and we can set this for a pretrial on January 21st at 8:15 a.m.
Thank you, Your Honor.
We do need fingerprints in this file, so I have just signed an order for fingerprints. So Mr. Collar, when we're done here with the hearing, I'll ask you to just sit down and back in the gallery where we'll make a copy of this order for prints and give you a copy of that before you go. You can take that order to the City of Adrian Police Department Monday through Thursday at 7:30 a.m. and they'll do your fingerprints for you.
Even if they're already like on file?
We have to have new
Okay.
fingerprints for each case file. So if you've had other files where we've done fingerprints, it doesn't help us here. We need a new set.
Okay, good. That's fine.
Okay. All right. Anything else we need to address today, Mr. Sneed or Ms. Underwood?
No, thank you.
Nothing else, Your Honor. Thank you.
Okay. So Mr. Collar, if you take a seat, we'll get you that order and you can go on your way.
All right, thank you, sir.
Thank you. This stuff. Okay, Ms. Underwood, do you need to speak to Mr. Cruz?
All right, anything new with you? Any court dates?
I believe we're ready, Your Honor. I believe there's a plea that's on the table and the court has been given an advice of rights.
Okay. This is file 25-22454-FH, People of the State of Michigan versus Christopher David Cruz. We are here today for a pretrial conference in this case, and we're proceeding today by video conference. First, we have the attorneys place their appearances on the record, beginning with Mr. Burke.
Your Honor, good morning. For the record, Mark Burke, P54935, on behalf of the Attorney General's Office appearing for the people.
Rhonda Underwood, on behalf of Mr. Cruz, Your Honor.
All right, and sir, you are Christopher David Cruz.
Yes, sir.
Ms. Underwood, where do we stand with Mr. Cruz's case today?
The offer from the prosecution is that Mr. Cruz will plead guilty to one count of failure to pay child abuse, failure to pay child support, a 4-year felony. The other counts and the habituals will be dismissed. And the agreement is that Mr. Cruz will be released at sentencing with a probation order, Your Honor, to get a job and pay. And as long as Mr. Cruz is paying, he stays out of jail.
Okay, Mr. Brooks had a complete and accurate statement of the plea agreement.
It is, Your Honor, yes. And specifically because there's 3 counts that have been filed in this case, the defendant would be pleading guilty to count 1, and people would be dismissing counts 2 and 3, as well as the habitual second. So that is correct what Ms. Underwood indicated. Thank you.
Okay. Mr. Cruz, would you raise your right hand, please? You swear or affirm to tell the truth, the whole truth, and nothing but the truth under penalty for perjury?
Yes, sir.
And you are Christopher David Cruz?
Yes, sir.
Mr. Cruz, you've heard the statement of your attorney and the prosecuting attorney. Is it your intention to plead guilty today to count 1, failing to pay child support?
Yes, sir.
Do you understand that the maximum possible penalty for that offense is up to 4 years in prison and or a $2,000 fine?
Yes, sir.
Are you satisfied with Ms. Underwood and the advice that she's given?
Yes, sir.
Either the prosecutor, defendant, or anyone acting on the defendant's behalf has discussed a possible sentence with court other than as we discussed it on the record here this morning. Is that correct, Mr. Burke?
That's correct, Your Honor.
Ms. Underwood?
That's correct, Your Honor.
Is that also your understanding, Mr. Cruz?
Yes, sir.
You can put your hand down if you like, Mr. Cruz. If a guilty plea is accepted, there'll be no trial. That means you're giving up the rights that you would have had at trial. I'm going to explain those to you right now to make sure that you understand them. You do have the right to a speedy public trial by jury. You could ask for a non-jury trial. If the prosecutor and the court agreed, you could have a non-jury trial. You have the right to be presumed innocent until proven guilty beyond a reasonable doubt. You have the right to have the prosecuting attorney prove beyond a reasonable doubt that you're guilty, and you do not have to prove anything. You have the right to be present at your trial, to have the witnesses against you appear at your trial, and to ask those witnesses questions. You have the right to have the court order any witnesses you have for your defense to appear at your trial. You have the right to remain silent during your trial and not have that silence used against you. However, you also have the right to testify at your trial if you wanted to testify. Do you understand, Mr. Cruz, that if your plea is accepted, you may be giving up the right to appeal issues that would otherwise be appealable if you were convicted at a trial?
I do, Your Honor.
You also understand that any appeal from the conviction and sentence pursuant to your plea would be by application for leave to appeal and not by right?
Yes, Your Honor.
If you are not a citizen of the United States of America, conviction of a crime can result in deportation, exclusion from admission to the United States of America, or denial of naturalization. Do you have any questions about any of those rights?
No, Your Honor.
Do you understand that you're giving them up?
Yes, sir.
How do you wish to plead to the charge that on or about February 1st, 2022 through February 28th, 2023 in the city of Adrian, County of Lenawee, state of Michigan, that you did commit the offense of failing to pay child support?
Guilty, Your Honor.
Has anybody made any threats or promises to you to induce you to plead guilty to that charge?
No, sir.
Do you understand that if I accept your plea, you're giving up any and all claims that your plea was given as a result of threats or promises that were not disclosed to the court on the record today, or that it was not your own choice to enter the plea?
I do, Your Honor.
Is the prosecutor or defense counsel aware of any promises, threats, or inducements other than the plea bargain to induce Mr. Cruz to plead guilty today?
None from the people, Judge. Thank you.
No, Your Honor.
Mr. Cruz, has your attorney promised you any particular sentence or estimated what your sentence would be?
No, Your Honor.
If your plea is accepted and you engage in misconduct, the court will not be bound by any sentencing agreement or evaluation. Misconduct includes, but is not limited to, absconding or failing to appear at sentencing, violating bond conditions, violating the terms of any plea or sentence agreement, or otherwise failing to comply with an order of the court pending sentencing. Do you understand that?
Yes, sir.
Is it your own choice to plead guilty today?
Yes, Your Honor.
Ms. Underwood, would you like to establish the factual basis?
Thank you, Your Honor. Mr. Cruz.
Yes, ma'am.
Back between the dates of February 1st, 2022 and February 28th, 2023, in the city of Adrian, county of Lenawee, state of Michigan, you had a child support order in case number 2017-043749 DS in the Lenawee County Circuit Court, correct?
Yes.
And you had a child support order in that case, correct?
Yes.
And you did not pay your child support during that period according to that order. Is that correct?
Yes, that's correct.
And you know that to be a crime.
Yes, that was wrong of me, ma'am.
Yeah. I believe the facts have been established, Your Honor.
Mr. Burke, are people satisfied with the factual basis?
People are satisfied, Judge. Yes, thank you very much.
Has the court complied with MCR 6.302 B, C, and D, Mr. Burke?
The people are satisfied. Yes, Your Honor. Thank you.
Ms. Underwood?
Yes, Your Honor.
Okay, I'll accept the plea then. It's been given understandably, voluntarily, and accurately. Mr. Cruz has had full knowledge of his rights and has had competent counsel. Court has not made any agreement regarding the possibility of a plea or sentence in this case with prosecutor, defense attorney, defendant, or anyone acting in the interest of any other than as we've discussed on the record here today. I will refer this matter to the probation department for a pre-sentence investigation, and we will set sentencing for January 16th at 8:15 a.m.
Thank you, Your Honor.
Your Honor, thank you very much.
Yep, you're welcome. Mr. Cruz, someone from the probation department is going to be in touch with you to do a pre-sentence investigation interview. When you do that interview, please be truthful about your offense and about your background.
Yes, Your Honor.
Okay, Mr. Fry, I have Ms. Pate here in the courtroom. Do you need to speak to her?
I do, Your Honor.
Okay, Ms. Pate, if you'll step outside, there's an iPad right out the door to your left.
Your Honor, have a good holiday.
Thank you. You too, Mr. Burke.
Thank you very much. Ms. Underwood, have a good holiday. Always nice to see you.
All right, Ms. Pate, give me just 1 second. I'll set up a breakout session for you and Mr. Fry.
Okay, thank you.
Hi, Trenton, how are you? Yes, how are you? Real good. All right. Okay, so I made you a copy of the bond conditions. All right. Keep this, because if you do, if you take a plea on it, you go before the PO, it's going to present that to the PO. Okay. So basically the bond conditions are, what we come over.
Okay, so Mr. Dagger Margosian, are you ready to proceed with Mr. Ketzner?
Yes, Your Honor.
And it's my understanding there's a co-defendant, Ms. Stout, in this case. Do we want to do these together?
Judge, that might make sense.
Yeah, that would be good, Your Honor.
Okay, let me bring Ms. Stout in. All right, this is file 25-22372-FH, People of State of Michigan versus Nancy Elizabeth Stout. Also file 25-22364-FH, People versus Jonathan Tucker Kensner. We are here today for a pretrial conference in both of those cases. First, can I have the attorneys place their appearances on the record, beginning with Ms. Arnold.
Allison Arnold for the people.
Good morning, Your Honor. May it please court, Todd Kaluzny on behalf of Nancy Stout.
Your Honor, Michael Dagger Margosian, filling in for Mr. Glazier for Mr. Ketzner.
Okay, and so I guess Mr. Dagger Margosian, let me start with Mr. Ketzner's case. Where are we with that one?
Your Honor, I spoke to Mr. Ketzner in a breakout room. I also reviewed the notes in the file left by Mr. Glazier. My understanding is there may be evidentiary issues that Mr. Glazier wants to explore further, maybe file a motion. For our side of the case, I would be asking the court for an adjournment for Mr. Glazier to file something with the court.
Mr. Kaluzny, let me ask you about Ms. Stout's case.
Your Honor, I just received an offer from Ms. Arnold yesterday, and it's something that I need to thoroughly discuss in person with my client. And so we need more time. And now that I know that there's going to be motions filed for an evidentiary hearing, I'd like to take a look at those before we make any decisions.
Okay, Ms. Arnold, anything we need to address from the people's side?
Judge, I think we will probably go ahead and file. I was going to do a 404B notice on Mr. Ketzner's, the incident that he's currently incarcerated in prison for that to come in under MRE 404B, but I'll probably just go ahead and do a motion in limine on that. So I think if the court sets a deadline for both sides to file any evidentiary related motions and both sides, or I guess all three sides, whatever, to respond, I think that would be appropriate.
I don't have any objection to that, Your Honor.
I'm gone from the 23rd to the 5th, so I need a little bit of time after the first of the year, and I know we're going to butt up against the court being rather occupied in the winter, but if we could find some dates, I think that'd be appropriate.
And Your Honor, I would ask for something, if our next court date to be after January 7th, because I'm going to be out of town.
Your Honor, may I state something on the record?
Mr. Ketzner, you're represented by an attorney, so if you want to, I don't know what the issue is, but if you want to talk with your attorney again, I can let you do that, and he can let me know what you're represented by an attorney. So what I'm going to do is set a pretrial conference for January 21st at 8:15 a.m. And I'm going to use that date for also as a deadline for the filing of any evidentiary motions. I would also say at that point that these cases will be about 170 to 180 days past since they've been bound over, and I would be setting those for trial at that point if there's not a resolution.
Judge, I certainly want to have quick trial dates. The only thing I would point out is if the evidentiary motions might be dispositive, it might be better to give a response time and have a quick hearing on those and then set a trial date after that.
All right, well, I'll consider that once I see the motions.
All right. Thanks, Judge.
Thank you, Your Honor.
All right, is there anything else we need to address on this case, these cases today then?
Not on
No.
behalf of the people.
No, but I did see that, I don't know if Mr. Ketzner wants to talk about the breakout room post-hearing.
Mr. Ketzner, do you want to speak to Mr. Dagger Margosian again?
No.
Okay. Nothing further, Judge.
And we don't have anything further on behalf of Ms. Stout. Thank you, Your Honor.
All right, thank you then. You're all set. Mr. Klesner, you can go ahead and log off, Ms. Stout, and Mr. Kester, same for you.
And Nancy, I'm going to be seeing you this morning.
Okay, yep.
Okay, Ms. Fry, you ready to proceed with Ms. Pate?
Yes, Your Honor.
Okay, so this is file 25-22449-FH, People of the State of Michigan versus Savannah Ray Pate. We are here today for a conference in this case, as well as an order to show cause regarding an alleged bond violation. We are proceeding today by video conference. First, going to have the attorneys place their appearances on the record, beginning with Ms. Arnold.
Allison Arnold for the people.
Brian Fry on behalf of Savannah Pate.
Okay. And Miss, you are Savannah Ray Pate.
Yes.
Ms. Pate, have you received a copy of the motion affidavit in order to show cause?
I did.
That document alleges that you violated your bond conditions by testing positive for cocaine and THC on November 21st and November 26th. And also that you had a positive drug screen for cocaine and THC on October 27th of 2025. Do you understand?
Judge, in addition to that, on December 6th and also December 11th, she was positive for cocaine. So now we're up to 4 positives.
All right. Do you understand that the maximum possible penalty for a contempt of court is up to 93 days in jail or up to $7,500 in fine? I'm sorry? Mr. Fry, do you know how Ms. Pate would like to proceed with respect to these bond condition violations?
Yes, Your Honor. So I have spoken to my client about the violations. She wishes to plead not guilty at this time. My understanding is that she sent these tests out to the lab for confirmation. She denies using cocaine. My understanding, as far as I've heard, is we haven't gotten the results from the lab back yet.
All right, I will enter a not guilty plea for Ms. Pate on the bond violations. And Mr. Fry, where do we stand with respect to the underlying case?
Yes, Your Honor, this is the first pretrial. We'd be asking for an adjournment of the pretrial and ask for a second pretrial in this case. It's still a pretty young case, and we're working through some evidentiary issues, and I also want to talk to the prosecutor a little bit more about potential resolution. There's another related case that has an effect on this case and getting this one resolved.
Ms. Arnold, anything that you would like to address from the people's side?
Judge, she's charged with some pretty serious charges, and 4 of the last 6 tests were positive. The likelihood that those are all inaccurate is extremely low. I think we should review her bond at this time. We also have another delivery case potentially coming that involve the death of an individual. So our concern is if she's out, 1, if she's using, she's a danger to herself, certainly. But 2, if she's using and she's possessed with intent to deliver or delivered cocaine in the past, she's a danger to others. So we would ask that the court increase her bond at this time and set this matter for a prompt hearing on the contempt and bond violation if that's what she wants to do, if she's denying these 4 positive tests.
Mr. Acosta, do you know the status of the samples that were sent to the lab?
Judge, I did not receive verification. I just sent an email to the director of the center over there asking for those. I would like to do a oral swab on her today where I could get those results within 48 hours.
If I may, Your Honor. So, Your Honor, my client, has clearly continued testing. She hasn't missed her test. She continues to do her tests. I'm very involved in, a recovery court, for instance, and, in that program, we've had people that have consistently tested positive for a substance and confirmations consistently come back that they weren't actually using. There's certain things, certain medications that can consistently cause positives. I mean, I don't know if that's what's going on here. Obviously, my client denies use, but until we get the confirmations from the lab, we aren't going to have a good answer. The urine screens are not actual drug tests. They're screens that have a pretty high, error rate. So, we would oppose, any incarceration until we actually get, some lab results to actually give a better answer on what's going on here.
All right, well, I'm looking at a file that has a contempt that was started down in district court. I can't exactly, it's a violation of bond condition. She pled not guilty there. I can't exactly determine at the moment what that is. And I have a bunch of positive cocaine tests. I acknowledge that there are occasions when it happens that tests give false positives. I would also acknowledge that those are not that common of circumstances, in my opinion. They're far more often correct than they are incorrect. I think that taking a swab sample at this point is appropriate. So, Ms. Pate, I'm asking you to step into the hall. Mr. Coast will meet you in the hall to do a swab test, and we'll see what the results of that are.
And Judge, I'll do the swab test today, but I do need to send that out, so I will not get the results for about 48 hours. If you'd like, I could get a female monitor. We could do a urine test with one of my cups, which will get immediate results.
For the moment, what I'm going to do is leave bond where it is and ask you to do the swab test with Mr. Coast, and then we'll make a decision on what happens in when we receive the results of that back. So we will set this for a pretrial on January 21st at 8:15. All right, so January 21st at 8:15 a.m. Ms. Pate is going to be your next date, and please step out to the hall and wait for Mr. Coast out there.
I can prepare a stipend order to adjourn the pretrial. If I do that, Ms. Arnold, could I sign your name with permission?
You certainly can.
Thank you.
Okay, thank you for that, Mr. Fry. Ms. Underwood, do you need to speak to Mr. Cole?
Your Honor, I'm on Mr. Cole.
Oh,
I don't believe so. I think we're ready to proceed.
Okay. This is file 25-22489-FH People of State of Michigan versus Michael Patrick Cole. We are here today for a pretrial conference in this case, and we are proceeding today. I'm sorry, we're here for an arraignment today, and we're proceeding today by video conference. First, can I ask the attorneys to place their appearance on the record, beginning with Mr. Sneed?
Isaac Sneed for the people.
Your Honor, Michael Dagger Margosian for Mr. Cole.
And sir, you're Michael Patrick Cole?
Yes, sir.
Mr. Dagger Margosian, does Mr. Cole wish to have the information read this morning?
No, Your Honor, and for arraignment purposes, we'll plead not guilty. However, we will be entering a plea. We have reached a resolution.
Okay. Do you have a signed advice of rights form from Mr. Cole?
I don't. I was wondering if maybe jail staff could get that to him.
We'll call and ask them to do that right now.
Okay.
Great, thank you. Ms. Underwood, I have Mr. Skinner here. Do you need to speak to him?
Thank you, Your Honor.
So just read this over, sign the back to your best ability.
Your Honor, I believe Mr. Skinner might be a show cause.
I think it's a show cause he's already been arraigned on, yeah.
Okay, okay.
Mr. Skinner, I'm going to put you in a breakout session with Ms. Underwood. Okay, Mr. Cole, have you signed that form?
Yes, sir.
Okay, Mr. Dagger Margosian, do you want to state the terms of the plea agreement?
Your Honor, Mr. Cole will be pleading guilty to counts 2 and 3, and in exchange, counts 1 and 4 will be dismissed. Further, the people will be recommending a year of jail.
Is that a complete and accurate statement of the plea agreement, Mr. Sneed?
No. In addition, we'll be dismissing any habitual offender supplement And in addition, there is restitution of $34.99 that shall be paid by defendant to Harbor Freight, and $221 in currency shall be released by the Adrian Police Department to the owner, Aaron Hips. And with that, there's nothing further.
Okay, Mr. Dagger goes in with those changes or additions. Is that a complete and accurate statement of the agreement?
Yes, Your Honor.
Mr. Cole, would you raise your right hand? Do you swear or affirm to tell the truth, the whole truth, and nothing but the truth under penalty for perjury?
Yes.
And you are Michael Patrick Cole?
Yes.
Mr. Cole, you've heard the statement of your attorney and the prosecuting attorney. Is it your intention to plead guilty today to count 2, larceny in a building?
Yes.
Do you understand that the maximum possible penalty for that offense is up to 4 years in prison and or a $5,000 fine?
Yes.
Is it also your intention to plead guilty today to count 4, third-degree retail fraud?
Yes.
Do you understand that?
It's count 3 that he's pleading guilty to.
Oh, thank you. I apologize. I apologize, Mr. Cole. Is it your intention to plead guilty today to count 3, breaking and entering a coin-operated device?
Yes, Your Honor.
Do you understand that the maximum possible penalty for that offense is up to 3 years in prison and or a $1,000 fine?
Yes.
If a guilty plea is accepted, there'll be no trial. That means you're giving up the rights that you would have had at trial. I'm going to explain those to you now to make sure that you understand them. You do have the right to a speedy public trial by jury. You could ask for a non-jury trial, and if the prosecutor and the court agreed, you could have a non-jury trial. You have the right to be presumed innocent until proven guilty beyond a reasonable doubt. You have the right to have the prosecuting attorney prove beyond a reasonable doubt that you are guilty, and you do not have to prove anything. You have the right to be present at your trial, to have the witnesses against you appear at your trial, and to ask those witnesses questions. You have the right to have the court order any witnesses you have for your defense to appear at your trial. You have the right to remain silent during your trial and not have that silence used against you. However, you also have the right to testify at your trial if you wanted to testify. Do you understand, Mr. Cole, that if your plea is accepted, you may be giving up the right to appeal issues that would otherwise be appealable if you were convicted at a trial?
Yes.
Do you also understand that any appeal from the conviction and sentence pursuant to the plea would be by application for leave to appeal and not by right?
Yes.
If you are not a citizen of the United States of America, conviction of a crime can result in deportation, exclusion from admission to the United States of America, or denial of naturalization. Do you have any questions about any of those rights?
No, sir.
Do you understand that you're giving them up?
Yes, sir.
How do you wish to plead to the charge that on or about October 17, 2025, in the city of Adrian, County of Lenawee, State of Michigan, that you did commit the offense of larceny in a building?
Guilty.
And how do you wish to plead to the charge that on October 17, 2025, in the city of Adrian, County of Lenawee, State of Michigan, that you did commit the offense of breaking and entering a coin-operated device?
Guilty.
Has anybody made any threats or promises to you to induce you to plead guilty to that charge, those charges?
No, sir.
Do you understand that if I accept your plea, you're giving up any and all claims that the plea was given as a result of threats or promises that were not disclosed to the court on the record today, or that it was not your own choice to enter the plea?
Yes, sir.
Prosecutor defense counsel aware of any promises, threats, or inducements other than the plea bargain to induce Mr. Cole to plead guilty today?
No, Your Honor.
No, Your Honor.
Mr. Cole, has your attorney promised you any particular sentence or estimated what your sentence would be other than as we've discussed it on the record here today?
No.
If your plea is accepted and you engage in misconduct, the court will not be bound by any sentencing agreement or evaluation. Misconduct includes, but is not limited to, absconding or failing to appear at sentencing, violating bond conditions, violating the terms of any plea or sentence agreement, or otherwise failing to comply with an order of the court pending sentencing. Do you understand that?
Yes, sir.
Is it your own choice to plead guilty today?
Yes, sir.
Mr. Dagger-Margosian, would you like to establish the factual basis?
Mr. Call, on October 17th of 2025, this year, were you in the city of Adrian County, Illinois, state of Michigan?
Yes.
And on that date, did you break into a coin-operated machine?
Yes.
And did you take money from that machine?
Yes.
And the machine was located inside of in a restaurant?
Yes.
Okay. And you broke into the machine with the intent to steal the money inside?
Yes.
All right. You didn't have like any legal reason to do that or justification or anything?
No.
Okay. I'm satisfied, Judge.
People are satisfied, Judge.
All right, has the court complied with MCR 6.302 B, C, and D, Mr. Sneed?
Yes, thank you.
Mr. Dagger-Margosian?
Yes, Your Honor.
Okay, I'll accept the plea then. It's been given understandably, voluntarily, and accurately. Mr. Cole has had full knowledge of his rights. He's had competent counsel. The court's not made any agreement regarding the possibility of a plea or sentence in this case with the prosecutor, defense attorney, defendant, or anyone acting in the interest of any of them. I will refer this matter to the probation department for a pre-sentence investigation and set sentencing for January 30th at 8:15 a.m.
Your Honor,
Mr.
I'm sorry. I'm out of the state on that day. Could we get a different sentencing date? I'm sorry.
How about February 5th at 8:50?
Perfect. Thank you.
So February 5th at 8:15 a.m. Mr. Call, someone from the probation department will be in touch with you to do a pre-sentence investigation interview. When you do that interview, please be truthful about these offenses and about your background.
Okay. May I please speak to my under real quick?
That's fine.
Yes, 1 second. Okay, Ms. Underwood, are you ready to proceed with Mr. Skinner?
Yes, Your Honor. Thank you.
This is file 24-22029-FH, 24-22031-FH, People versus Patrick Lee Skinner. We are here today for a hearing on probation violation, and we're proceeding today by video conference. Ms. Underwood, would you like to place your appearance on the record?
Rhonda Underwood for Mr. Skinner this morning, Your Honor.
Yeah, and sir, you are Patrick Lee Skinner.
Yes, sir.
Ms. Underwood, where do we stand with Ms. Skinner's
We would
case
ask
today?
the court to continue the not guilty plea on Mr. Skinner's behalf. Mr. Skinner, I believe, wants a hearing on this matter, Your Honor. He's on his way today to Battle Creek to the Veterans Facility now that he has his benefits for rehab, Your Honor. So we would ask for a date, maybe the end of January.
All right, let's go with January 28th at 8:15.
Thank you, Your Honor.
Okay, Mr. Your next date is January 28th at 8:15. You can log in on Zoom using all the same Zoom information that you used today.
Yes, sir. Thank you.
Okay, you're all set then. You can log out. And Mr. Daly, Mr. Woost is here by video conference. Are you ready to proceed with?
Yes, Your Honor.
-22406-FH, people of the state of Michigan versus Michael Lee Woost.
West, Your Honor.
West. So we are here today for a pretrial conference in this case, and we are proceeding today by partially in person and partially by video conference. First, going to have the attorneys place their appearance on the record, beginning with Mr. Sneed.
Isaac Sneed for the people.
James Daly, Green Raft, defendant, West.
Okay, and I just sent Mr. West a request to unmute his device.
Okay.
Okay, Mr. West, can you hear me?
Yes.
All right, you are Michael Lee West?
Yes, it's pronounced Weast. W-U-E-S-T, yes.
All right, let's see. Mr. Daly, where do we stand with Mr. Weest's case today?
He is going to enter a plea today. The plea bargain has been arranged with the prosecutor's office. We're prepared to enter the plea at this time. He'll be pleaded guilty to count 4, attempt to control substance possession.
Mr. Is that a complete and accurate statement of the plea agreement?
Just to be clear, was attempted added count for attempted possession of methamphetamine. The people are recommending a sentence of no immediate jail and will dismiss all the remaining charges, Your Honor.
Okay. Is that all accurate, Mr.
Weist?
Yeah, Mr. Weist, is that your understanding of the plea agreement?
Yes. Can I ask one question? If nobody minds.
What's your question?
I have a lot of health issues now. It's just getting worse, and I was just wondering if what would be the fines and costs and everything, and so I can just pay that and and be done, because
Was that those issues will all be resolved, but a plea has to be entered first before we get that done. Everybody's aware of his health issues.
Okay.
And he's pretty limited in what he can do, where he can.
Okay, so Mr. Weist, that is something that I can't assess until the sentencing hearing, and we can't have a sentencing hearing until you've entered a plea. But we can take that, all under consideration at the appropriate time.
Okay. All right, because that's fine. That's why I asked, because I can't walk another 5 feet without wanting to stop.
Okay. All right then, Mr. Weist. So you've heard the statement of your attorney and the prosecuting attorney. Is it your intention then to plead guilty today to count 4 attempted possession of methamphetamine?
Yes.
Do you understand that the maximum possible penalty for that offense is up to 10 years in prison and or a $15,000 fine?
Yes.
You're satisfied with Mr. Daly and the advice that he's giving?
Yes.
Neither the prosecutor, defendant, or anyone acting on the defendant's behalf has discussed a possible sentence with the court other than as we've discussed it on the record here this morning. Is that correct, Mr.
It is, Your Honor.
Yes, Your Honor.
Is that also your understanding, Mr. Weist?
Yes.
If the guilty is accepted, there'll be no trial. That means you're giving up the rights that you would have had at trial. I'm going to explain those to you now to make sure that you understand.
Right.
You have the right to a speedy public trial by jury. You could ask for a non-jury trial, and if the prosecutor and the court agreed, you could have a non-jury trial. You have the right to be presumed innocent until proven guilty beyond a reasonable doubt. You have the right to have the prosecuting attorney prove beyond a reasonable doubt that you are guilty, and you do not have to prove anything.
Right.
You have the right to have the court order any witnesses that you have for your defense to appear at your trial. You have the right to be present at your trial and to have the witnesses against you appear at your trial and ask those witnesses questions. You have the right to remain silent during your trial and not have that silence used against you. However, you also have the right to testify at your trial if you wanted to testify. Do you understand, Mr. Weiss, that if your plea is accepted, you may be giving up the right to appeal issues that would otherwise be appealable if you were convicted at a trial?
Yes. Understand.
Do you also understand that any appeal from the conviction and sentence pursuant to the plea would be by application for leave to appeal and not by right?
Yes.
If you are not a citizen of the United States of America, conviction of a crime can result in deportation, exclusion from admission to the United States of America, or denial of naturalization. Do you have any questions about any of your rights?
No, but I am a U.S. citizen.
Okay. Do you understand that you're giving those rights up?
Yes.
How do you wish to plead then to the charge that on or about July 19, 2025 in the city of Adrian, County of Lenawee, state of Michigan, that you did commit the offense of attempted possession of methamphetamine?
Guilty.
Has anybody made any threats or promises to you to induce you to plead guilty to that charge?
No.
Do you understand that if I accept your plea, you'll be giving up any and all claims that your plea is given as a result of threats or promises that were not disclosed to the court on the record today, or that it was not your own choice to enter the plea?
Yes. I understand.
Is the prosecutor defense counsel aware of any promises, threats, or inducements other than the plea bargain to induce Mr. Wiest to plead guilty today?
No.
No, Your Honor.
Oops.
Mr. Wiest, has your attorney promised you any particular sentence or estimated what your sentence would be other than as it's been discussed on the record this morning?
No.
If your plea is accepted and you engage in misconduct, the court will not be bound by any plea or sentencing agreement or evaluation. I'm sorry, any sentencing agreement or evaluation. Misconduct includes, but is not limited to, absconding or failing to appear at sentencing, violating bond conditions, violating the terms of any sentence agreement, or failing to appear with any order of the court pending sentencing. Do you understand that?
Yes.
Is it your own choice to plead guilty today?
Yes.
Mr. Daly, would you like to establish the factual basis?
Yes, Your Honor. Mr. Lewis, on July 19th, 2025, were you present in the city of Adrian, County of Lenawee?
Yes.
And at that time, were you stopped by the police?
Yes.
And did they search your car?
Yes.
Your vehicle?
Yes.
And in the vehicle, did they find cocaine that was in a work tool bag?
Yes. Yeah.
And that you're agreeing that that was your cocaine?
Yes, it's in my vehicle. Yes.
I have no other questions, Your Honor.
Was it cocaine or was it methamphetamine?
I'm sorry, methamphetamines.
Mr. Weiss, was it methamphetamine rather than cocaine?
Yes, that's what he said, and yes.
Okay.
Yes.
All right, Mr. Sneed, are the people satisfied with the factual basis?
Yes, thank you, Judge.
Has the court complied with MCR 6.302 B, C, and D, Mr. Sneed?
Yes, thank you, Your Honor.
Yes, Your Honor.
Okay. I will accept the plea that's been given understandably, voluntarily, and accurately. Mr. Weiss has had full knowledge of his rights and has had competent counsel. Court's not made any agreement regarding the possibility of a plea or sentence in this case with the prosecutor, defense attorney, defendant, or anyone acting in the interest of any of them. I will refer this matter to the probation department for a pre-sentence investigation and set sentencing for January 30th at 8:15 a.m. Mr. Weiss, someone from the probation department will be in touch with you to do a pre-sentence investigation interview. When you do that interview, please be truthful about the offense and about your background.
Yes. Oh, yeah.
And Michael,
All right.
I'm going to see you on Friday for a drug test.
All right, I'm sorry to say, if my swelling's down, I have to get in the shower to use the restroom. I'm sorry. You there?
Okay, Mr. Weiss, I'm going to put you in a breakout session with Mr. Stevenson from the probation department so that he can collect your contact information.
All right. Okay.
So go ahead and click accept or tap accept or join or whatever it's asking you to do on your phone.
Join. Okay.
Yeah.
Yes. Okay.
Okay, thank you, Mr. Chair.
Thank you, Your Honor.
And Mr. Hartung, what case are you here for?
Juan Harris and Derek Bakke.
Okay.
Both. No, Bakke's John Glazer, but
You don't have Malero, Mr. Malero. You did. Mr. Bakke was logged in. He's not logged in any longer.
is he logging in from rehab still?
I don't know.
Okay.
Because I didn't get a chance to speak to him. Mr. Dagger-Margosi, do you have any contact information to try to contact Mr. Bakke?
Judge, I'm looking at the notes in this case. I can try to call him. Frankly, I was just going to ask to adjourn the case, but I can try to call him if the court wants me to.
Thanks, sir. Here. See you later now.
Yes, could you try to give him a call, please?
Sure. One moment.
Your Honor.
Yeah.
Have we called Zachary Wilson case yet?
I do not believe I have.
Okay. I just want to make the court aware because he is on probation with us. And as of just a few minutes ago, I've confirmed that he's absconding. I may request a show cause, however, he hasn't been at his residence, according to his mother, for 2 months. So I don't think he'll show up today.
Okay, that is Mr. Malero's case, so I'll call that when Mr. Malero gets logged in with me.
Okay, thank you.
Okay, Mr. Dagger-Margosi, I do have Ms. Nicholas here. Do you need to speak to her?
Probably not, unless she would like to speak with me.
Ms. Nicholas, I'm going to send you a request to unmute your device.
Okay.
Do you need to speak to Mr. Dagger-Margosi before we call your case?
I don't believe so.
Okay. This is file 25-22170-FH, People of the State of Michigan versus Brenda Lee Nicholas. We are here today for a here today for a pretrial conference in this case. We are proceeding today by video conference. First, going to have the attorneys place their appearances on the record, beginning with Mr. Sneed.
Isaac Sneed for the people.
Your Honor, Michael Dagger Margosian for Ms. Nicholas.
And where do we stand with Ms. Nicholas's case today?
Your Honor, if the court would recall, we had adjourned the last hearing so that we could get the preliminary exam transcript. This case was originally with Mr. Daly, but there was subsequently he had to withdraw, so we had to file an appearance, and we asked for the exam transcript. My understanding is the transcript has been prepared. It was sent to Mr. Daly's office, I think sometime last week, and so I think it was now put in our mailbox over at the courthouse, so we need to pick it up and review it. I do expect that this case will be set for trial, but I need an opportunity to review the exam transcript, please.
Okay. Mr. Sneed, is there anything we need to address from the people's side?
There is not. Thank you, Your Honor.
Okay, so let's set this then for a pretrial conference on about January 28th.
That's fine. Thank you.
And Mr. Dagger Margosian, could you do a stipulation in order for that adjournment?
Yes, Your Honor.
Okay, if there's nothing else, we're all set. And Ms. Nicholas, your next date is January 28th. You can log in with all the same Zoom information that you used to log in today.
Okay, thank you very much. Do I go now?
Yes, you can go ahead and log out.
Okay, thank you.
And then Mr. Dagger Margosian, I have Ms. West here. Do you need to speak to her?
What is it?
Taisha West?
Yes, please. I had it listed as a different last name.
Oh, okay. Okay, Ms. West, I'm going to send you a request to unmute your device. And now I'm going to put you in a breakout session with Mr. Dagger Margosian, if you give me just a moment. He's not here. This is file 25-22122-FH, People of State of Michigan versus Jonathan William Bett. We are here today for a hearing on an order to show cause based on an alleged probation violation. We are proceeding today in person. The court also has a Zoom video conference session running. The record should reflect this matter was set for a hearing this morning at 8:15 a.m. Mr. Betts was ordered to appear for an arraignment on the alleged probation violation. It is now 10:05 a.m. Mr. Betts has not appeared at any point this morning, either by being present here in the courtroom or by logging into the court's Zoom session. I am going to issue a bench warrant for his arrest for the failure to appear, and I am going to set bond on that bench warrant in the amount of $50,000 cash assured. Certainly. Zoom is okay. Yes. Mr. Dagger Margosian, are you ready to proceed with Ms. West?
Yes, Your Honor, thank
you. This is file 25-22408-FH. Okay. All right, sir, we're on the record here. People of the State of Michigan versus Taisha Janetta West. We are here today for a pretrial conference in this case, and we are proceeding today by video conference. First, can I have the attorneys place their appearance on record, beginning with Mr. Sneed. Mr. Sneed, are you there?
Yes, Judge. Sorry.
All right, you want to, this is People versus West. Do you want to place your appearance on the record?
Yes, Isaac Sneed for the people.
Your Honor, Michael Dagger Margosian for Ms. West.
All right, and Mr. Dagger Margosian, where do we stand with Ms. West's case today?
Your Honor, I am covering for Mr. Glazier. I reviewed the plea offer that was sent to our office. I reviewed that with Ms. West. There are some items in the plea offer that Mr. Glazier is going to have to speak further with Ms. West about, namely the amount of restitution. But I think at this point, I would just be asking for a short adjournment for that to happen.
Mr. Sneed, is there anything we need to address from the people side?
Not at this time, Judge. Thank you.
All right, so what I'll do is set this for January 21st at 8:15 a.m.
Thank you, Honor.
So, Ms. West, your next date is January 21st at 8:15 a.m. You can log in using all the same Zoom information that you used to log in today. You were muted. I'm just saying your request to unmute. I saw that you said something.
Okay, Your Honor. Thank you.
All right, so you're all set then. You can go ahead and log out. Did you have any other cases? Well, you had Mr. Balky. Is that right, Mr. Tagliagosi?
Correct, Your Honor.
Did you have any luck contacting?
I called the number listed. It just went straight to voicemail. However, I did have a message from our staff that Mr. Baki had sentencing in another jurisdictions, and so I think that's probably why he logged off.
Mr. Coast, do you know whether Mr. Balky is still at rehab?
Judge, I actually tried getting verification of that through Emily White. She's been unsuccessful. I know he was attending Harbor Hall, but I can't verify if he's there or not.
Judge, 2 days ago, he had reached out to the court and wanted to adjourn his hearing date for today, and I told him to reach out to his attorney, and he'll reach out to the court. And that was due to him having another hearing in another county today.
Okay, I guess why don't you let me call the case then. This is file 25-22396-FH People versus Derek Mitchell Balky. We are here today for a pretrial conference on this case and proceeding today by partially in person, partially by video conference. First, let me ask the attorneys to place their appearance on the record, beginning with Mr. Hartung.
Thank you, Your Honor. Doug Hartung today for the people.
Your Honor, Michael Dagger Margosian for, but not with Mr. Baki.
All right, and there's been some discussion about, discussion off the record about Mr. Balky's current whereabouts. I understand a couple things. He may be at rehab, but we can't confirm that. I think he's been there in the past. He apparently contacted the court yesterday to ask for an adjournment, and Mr. Dagger Margosian believes he has a hearing in another court case this morning. So, Mr. Hartung, is there anything you'd like to address with respect to Mr. Balky this morning?
I believe all of those things are accurate. That would have to be put on the record, Your Honor. From my knowledge of it, I contacted Mr. Glazier on Monday, and he was not aware if he completed his rehab or not. But I was aware that he has another case in Jackson County. I think the court may have been too, and I thought the sentence was coming out before this hearing. I guess it's the day of the hearing, but I have no objection to the court setting a new date if that's what the court desires to do.
Okay. Mr. Dagger Margosian, anything you'd like to say with respect to the issue?
No, Your Honor, I think the adjournment would be appropriate and would make sense.
Okay. I do think that sounds reasonable under the circumstances. So what I will do is adjourn this to January 14th at 8:15 a.m. And Mr. Dagger Margosian, would you prepare a stipulation in order for that adjournment, please?
Yes, Your Honor.
Okay. Mr. Dagger Margosian, we have Mr. Guro that is a client of John Glazer's that was picked up on a bench warrant last night. Did you want to handle that, or do you want us to wait for Ms. Underwood?
I'm going to ask for the court to have Ms. Underwood handle that as she's more familiar with that procedure.
Okay.
All right, thank you.
Right. I think that's everything then that I had for you, Mr. Dagger-Magosi.
I think so too. Thank you, Your Honor.
Let's see the promise.
Are we ready to proceed in the Warner matter?
Yes, Your Honor. Good morning, Your Honor. Ashley Hampton Grimes on behalf of.
I've got to call the case first.
I couldn't hear you from the back, Your Honor.
This is file 25-21841-FC, the state of Michigan versus Dale Warner. We are here today for a hearing in the matter of Kevin Thomas Greca, for whom the court had issued a material witness order and subsequently last Friday, I believe, set a bond. First, can I have the attorney's place their appearance on the record, beginning with Ms. Wise for the people.
Good morning, Your Honor. Jackie Wise on behalf of the people. Good morning, Your Honor. Ashley Hampton Grimes on behalf of retired Detective Kevin Greca, who is also in the courtroom seated to my left.
Good morning, Your Honor. Mary Chartier on behalf of Dale Warner, who is participating via video.
Good morning, Your Honor. Marissa Vinsky, also on behalf of Mr. Warner.
Thank you. And the court at the hearing on Friday asked Mr. Greca if he would like to be represented by an attorney. At that point, he did indicate he would like to be represented by an attorney. The court set a bond at that time with the understanding that this hearing would go forward today, giving him a full opportunity if he wished to take advantage of to be heard on the issue of bond. So Ms. Hampton-Grimes will give you an opportunity at this point to say anything you'd like with respect to the issue of bond, or if you would prefer to take some testimony, you can do that as well.
Your Honor, although I'm not entirely privy to what happened on December 12th as it relates to the hearing that was conducted, I do understand that my client did not make a statement regarding, he did address bond in the court. Did not ended up setting a $50,000 surety bond. That surety bond has been paid and he is ultimately released. What we take issue with today, and if we are limited in our scope to a bond hearing today, which is what this was noticed as, is the bond conditions. And I would like to take some testimony today regarding that. I do take issue with how things were previously conducted, but we're not here to address those today, and I will file any appropriate motion that I will need to in order for you to consider that once I've reviewed the transcript.
That's fine. I do not have any bond conditions.
Yes, you do, Your Honor.
No, I do not. It is a $50,000 surety.
Oh, okay. They would be from the bonding agency. So I would just ask that there was one provision, there's 3 provisions, that he will comply with any orders from this court, that he will not leave the state of Michigan, and that he will make himself available for any and all court appearances. I've spoken with Ms. Wise. I do not believe that the provision regarding leaving the state of Michigan needs to be there. He has retained me. I'm a local attorney. He lives here locally. He's lived here for over 20 years. He was out to dinner. I want it to be very clear that he was not fleeing in any capacity. He was out to dinner in Ohio when your order was executed upon him. At that point, he then did have to come back. This idea that he was a fugitive from justice, under the definition of a fugitive from justice, simply doesn't apply. He hasn't been charged with anything, nor was he given any notice that your order from October was even in place. There was no tacking, there was no mailing of it to him, there was no indication that he knew anything that happened in the October 21st hearing and the order of attachment that came out of that hearing. So this idea that he is a fugitive and he's been labeled by the media is completely abhorrent to me, because he was out to dinner, as many of us go to dinner, given our close proximity to Ohio. So I do not believe that this is the case. I've talked to Ms. Weiss's office. We acknowledge service of the subpoena in this case. We acknowledge that we will cooperate with any pretrial statements that she may need from my client, just that I am to be present. We have no issue. I take issue with the hearings that were conducted in October, and I will be filing motions regarding those. But I take no issue going forward in having my client fully cooperate to the best of his ability. And at that point, not only with Mr. Warner's counsel, but with the Lenawee County prosecutor. What has been perpetrated upon my client, given his service to this county in the state of Michigan, is disgusting. There are many mechanisms that could have been used to effectuate notice, even to have notice effectuated to the October 21st hearing. The fact that I reviewed the file at 3:45 on Monday, and by 5 o'clock it is released to the media and unsealed, certainly does not seek to show that there was any thought to the safety of my client. And to go further forward, like, it indicates that there almost seems a willingness to paint him in a bad light. I, again, have many issues with the hearing that was conducted in October, but we're not here for that. However, I do ask that this court make the only condition, if there is to be conditions set. $50,000 cash surety bond has been paid. He is here, he is out, he is willing to cooperate. I anticipate working with Ms. Wise within the next 21 days. And that is to get through the holidays and to get through my scheduling. We have agreed to that. He is in agreement with that. He will testify, or he will state today that he is in receipt of the subpoena and that he fully intends to be bound by that and to make himself available to the prosecutor and to defense counsel.
All right, so I think I heard you request that the condition that he not leave the state of Michigan be, is that correct?
Correct, Your Honor.
Are you asking for anything else at this point?
If the court feels that the conditions are appropriate, I do not believe that they are. And again, because the surety bond has been paid and essentially he has not been charged with any offense, and your order has been effectuated and he has been served, I consider at this point that there should be no conditions at all. However, if the court would feel better about that, we are certainly agreeing that we have no problem saying that we will cooperate in the terms of the subpoena as it is ordered, because we do acknowledge receipt of it.
Okay, just for clarity's sake, there are no conditions on his bond that have been imposed by me other than the $50,000 cash or surety.
So then I would ask for an order stating that the bond condition of the bonding agency that states he is not allowed to leave the state of Michigan be removed pursuant to an order from you.
Okay, I'm not aware of any legal authority that I have to tell the bonding agency what additional conditions they may or may not want to put in place in order for them to issue their bond. I will say for the record, well, let me ask Ms. Wise to, if you have any input that you'd like to make give on this topic.
Your Honor, the fact that he's hired an attorney and he has appeared today does go a long way, but it doesn't change the fact that we had to look for him for 8 months, and he was in Ohio for a period of time. It wasn't just to go out to dinner. However, this court hasn't set that as a bond condition that he cannot leave the state of Michigan. That's understood. That's part of the bonding agency. I would leave it up to your discretion. I would, however, ask the court to make a bond condition that he does notify the court if he does change his address, if he does change his phone number. Those are the conditions I would be asking for, Your Honor.
Your Honor, pursuant to this pretrial release order, which is a scale motion, or a scale order, which is why I thought it did come from this court. It does say do not leave the state of Michigan without the permission of this court. I'm asking for the court to grant him permission, blanket permission to leave the state of Michigan.
All right, you are correct. That is in the form order on the pretrial release. That was. I'm sorry, Ms. Wise, did you say that you would leave that issue in the court's discretion?
In the court's discretion, Your Honor, based on the facts that the court has before it from previous hearings, yes.
Ms. Shardy, do you care to have any input on the topic?
The only input would be, I think that retired Detective Greca has acknowledged service of the subpoena. To my knowledge, there's never been an issue with him not attending court before. He's retained counsel who is aggressively representing him. If the bonding agency continues to require that Mr. Greca remain in the state of Michigan, but the court is willing to remove that condition, then one thing is the court could convert the bond to a PR bond. So that way there'd be no bonding agency involved at all to put any restrictions on Mr. Greca. And then it would just be restrictions by the court, which I think is just appearing in court. Thank you.
All right, I would first say, since the topic has come up, the court has never at any point tried to or even intimated that retired Detective Greca was a fugitive from justice or anything of the like. The court issued an order pursuant to MCL 767.35 for a material witness to be brought before the court for the purpose of having a hearing to determine whether a bond was appropriate. Anything else, I have been very careful to not even suggest, because we are operating under a very specific provision of the law, and that is the only provision of the law under which the court is operating at this point. I do think, given the fact that retired Detective Greca has obtained counsel and has posted a bond with the surety in the amount required by the court, that eliminating the form provision that he not leave the state of Michigan is appropriate. I'm obviously aware that we live very close to the Ohio border, and it's common for people to cross back and forth. And I'm comfortable in this case with retired Detective Greca doing that, given the bond and what's in place currently. So I would make that modification. Is there anything else we need to address today, Ms. Hanson-Grimes?
Your Honor, if the court would consider the comments made by counsel, perhaps of also converting the bond to a PR bond, that would be something we would like you to consider. The bond's already paid, and you made it a surety bond, so it's not a matter of retired Detective Greca getting his money back, because that's impossible, and the court made it impossible. So it's just a matter of releasing him from any conditions from a bonding agency, and I would leave that in the court's discretion.
I would object to any PR bond just based off of previous hearings, Your Honor. That's before this court.
All right, based on what I know of the case right now, I would leave the surety bond in place as a surety bond. If you, Ms. Hanson-Grimes, would like to present further evidence for me to consider in terms of, or for the purpose of reducing or changing that from a surety bond to the personal or cognizance bond, I'll give you an opportunity to do that. But as I stand right now with what I have before me right now, I would leave the surety bond in place.
Okay, Your Honor, I will perhaps brief that issue and bring it before the court if I do elect to make that change. I do feel that the surety bond at this point essentially has become punitive. He paid the 10% through a bail bondsman, and as is required in the surety bond, once a person pays a bail bondsman, they are not getting that money back. So essentially, this court's order did have the force and effect of being extremely punitive to him in exchange for the fact that he was also held in custody for multiple hours, as opposed to just being brought forth to the court as your order of attachment did suggest and pursuant to the statute. He did not, we kind of bypassed the fact that he would be able to come and make witness for himself as is required in your order of attachment under MCL 67.35, that he would have an opportunity to recognize for himself, yes, there is a subpoena out there for me. Yes, I expect that. Instead, we immediately went to bond, a surety bond that he is going to have to put, either still stay in jail today, which is well beyond the 72 hours that we would be looking at. And this order was also put in place 4 months or more before he is due to be in trial. So at this point, I think that things that have been done, and I will expound on them in further hearings, have an extreme punitive aspect to them. And so that is why I was asking you to consider that on the comments of counsel, because he's already out in a tremendous amount of money that he is not, because of the provisions put by this court, as opposed to just having it be a 10% bond or having it be a lower cash bond. He's not able to get that money back. And so if the court has a way or a mechanism that could indeed be converted, I would take any and all knowledge that you would expound upon that issue. But at this point, there is none. And so the punishment has been levied for an offense that he really didn't have a chance to answer for.
I would point to the statute MCL 767.35 as the court's basis for requiring a surety bond. That statute says nothing about a 10% bond. And so I did think about a 10% bond when making my decision on going forward. And in reading the statute, did not believe that that would be authorized by the statute. And so there's a reason that I did not do that. I have stated my reasons for maintaining the surety bond, which I'll do at this point. And if you'd like to have a further hearing on that or brief it in any way, you're welcome to do so.
Okay, thank you, Your Honor. At this point in time, there would be nothing more from the court. We will be requesting a transcript of the December 12th hearing. Would the appropriate mechanism be to file something with this court to get that transcript, or how is best for me to get that information?
There's, I believe, a scale form for that we asked.
Just because it was a sealed hearing, that's why I'm asking. I have nothing further today. If Ms. Weiss has anything further. I have nothing further, Your Honor.
Nothing further. Thank you.
Thank you. Okay, Mr. Hartong, we're still waiting on Mr. Malero. Oh, we have Ms. Underwood now. So I'm going to give and recognize there's some other people here that need to pack up and leave, so I'll give you all a few minutes to. If you need to do that.
Thank you so much, John.
Stay here. Yeah, I'm gonna stay here just so let's see, Ms. Underwood, you're back for Mr. All right, so Mr. Dickerson, Ms. Underwood had been logged in for most of this morning. I don't see him now. Can you try to get in contact with him?
I will, Your Honor. One moment, please.
Yeah.
everything else is suspect she's hearing me back now. Do you have any luck contacting him, Ms. Underwood?
Your Honor, I called Mr. Dickerson at the number we have. I've been calling Mr. Dickerson at that number for days, Your Honor. I get a voicemail.
Okay. All right, so hang on.
Your Honor, if I could ask.
Hang on, Rhonda. This is file 25-22396-FH, People of the State of Michigan versus Derek Mitchell-Walkie. We're here today for a pretrial conference. In this case, we're proceeding today by video conference. First, going to have the attorneys place their appearances on the record, beginning with Ms. Hoffman.
Good morning, Your Honor.
Oh,
Benita
I'm sorry.
Hoffman.
I called the wrong case. I apologize.
I was a little bit confused.
Try that again. So this is file 25-22403-FH, People versus Sean Dickerson. We're here on this case for a pretrial, and let me have the attorneys place their appearance on the record, beginning with Ms. Hoffman.
Good morning, Your Honor. Benita Hoffman, Assistant Attorney General on behalf of the people.
Rhonda Underwood for Mr. Dickerson this morning, Your Honor.
Yeah, and we have had some discussion off record. I had indicated to the attorneys that Mr. Dickerson had been present in the Zoom waiting room for, since I believe right at 8:15 this morning. It's now 10:49. He is no longer in the Zoom room. I don't know where he is, and Ms. Underwood had indicated she tried to call, but only was able to get a voicemail.
Your Honor, may I request that we set this over to next week? And I don't know if I have to send smoke signals out, what I have to do to get my hands on Mr. Dickerson. But hopefully, I think he demonstrated his good faith by appearing this morning, Your Honor. So I don't think he's avoiding court.
All right, Ms. Hoffman.
Your Honor, if he was here this morning, I would be inclined to agree with Ms. Underwood. I think putting it over to next week is probably the best strategy.
I think that's reasonable. As I said, he was here for at least a couple of hours in the waiting room, so it could be something as simple as his phone died. So I will adjourn this. We can't do next week or the week after because the court is closed on both of those days for the holiday. And
thank you.
We'll set this for January 7th is our next available court date at 8:15, if that date works.
Yes, Your Honor.
Okay. So January 7th at 8:15, Ms. Underwood, would you do a stipulation in order for that?
I would be happy to do that with Ms. Hoffman's permission.
Certainly. Thank you.
Thank you.
Okay. Thank you for your time then.
Thank you, Your Honor.
And Ms. Hoffman, when I talk to Mr. Dickerson, I will get back to you on a final with that.
Thank you. I appreciate it. Have a nice holiday, everybody.
You too.
Okay, Randy Douglas, they never logged in with him from whatever facility he's at.
I thought they were gonna bring him in person, but apparently they never did.
They were supposed to, the facility contacted Francis either yesterday or the day before and said that they were short-staffed and didn't have anyone to bring him, so they were gonna log him in on Zoom. But they
Okay,
didn't.
they didn't.
Also do that, so.
All right.
I guess we're just gonna have to pick another date for Mr. Douglas. Did you need him here in person for some reason, or?
I thought we did. We were gonna take a plea. I talked to him a couple of days ago. We're still gonna take a plea. What?
Okay. Maybe we needed an advice of rights form.
That could be it.
Okay. All right, so I'm going to set it for January 21st. Mr. Sneed, are you there?
I am, Judge.
Okay, so we're going to reschedule Randy Douglas to January 21st, and can you do an in-person writ for him?
Yes, we will, Judge.
Great, thank you.
Judge, Francis just called and asked me to let you know that that was for a different defendant, so she doesn't know anything about this one.
Okay. All right, well, we'll do the same thing with Mr. Douglas anyway.
Hey, and I will do the stip and adjournment with Mr. Sneed's permission.
Okay, thank you. And on cue, Mr. Dickerson is logged back in.
Oh no.
So I'll just bring him in and we'll let him know what happened.
And I'll get
Judge, I can call Ms. Hoffman.
Contact information.
Or yeah, Sierra, if you would want to call Ms. Hoffman, see if she could log back in real quick.
Well, Sierra, I'm gonna need to talk to him anyway. So
okay,
if it's okay with the court, we can leave it for the 7th.
Okay, Mr. Dickerson, are you there? I'll need you to unmute your device, please. Mr. Dickerson, if you're there, I need you to unmute the device. I've sent you a request to do that.
Can you hear
me? All
me?
right, can you hear me, Mr. Dickerson?
Yes, sir. Yes.
Okay, so you had dropped out of the meeting for a while when we called the case, and so we just adjourned this to January 7th at 8:15.
January 7th?
Correct.
John, you need to call my office and make an appointment to either talk to me by phone or come in. Okay?
All right, what's your number? What's the phone number?
264-5353.
5353?
Yeah.
I'll call right now.
Thank you.
Welcome.
All right, you're all set for today, Mr. Dixon. You can log out.
All right, thank you.
Can you call the jail? Someone's going to need to connect the audio from Mr. Burrow.
The room that Mr. Jerome is in, the audience. Thank you.
All right, Mr. Guerrero, are you able to hear me?
Yes.
This is file 25-22330-FH, People of the State of Michigan versus Richard James Guerrero Jr. We are here today for a arraignment on a bench warrant for allegedly violating bond conditions. We are proceeding today by video conference. Sir, you are Richard James Guerrero Jr.
Yes.
Sir Guerrero, have you received a copy of the motion affidavit and bench warrant?
Yes.
That warrant alleges that you failed to return to the Lenawee County Jail on December 5, 2025, after a doctor's appointment in Jackson, Michigan, to complete your 60-day contempt of court sentencing. That would be a violation of your bond conditions, subject to a maximum penalty of 93 days in jail or up to $7,500 in fines. You do have Public Defender's Office representing you on the underlying case. Do you want them to represent you on this as well?
Yes.
All right, I will put you in a breakout session with Ms. Underwood from the Public Defender's Office if you'll give me just a moment. So, Mr. Guerrero, you'll need to click accept or join. Thank you. All right, Mr. Fry, Ms. Wagner, if you want to come up and get yourself set up, you can do that. All right, we are back on the record in People versus Richard James Garreau Jr. Ms. Underwood, do you know how Mr. Garreau would like to proceed?
Your Honor, I'm going to ask the court to enter a not guilty plea for Mr. Garreau in this matter, Your Honor. And then I want to be able to address the issue of bond.
All right, I'll enter a not guilty plea. What would you like to say about bond?
Your Honor, it's my belief that the evidence will show that on the 5th, when Mr. Garreau went to the doctors, he was admitted to the hospital at U of M, where he was, I believe, till Sunday night with serious heart issues, Your Honor, and released on Sunday night. I believe he went home. Mr. Garreau is very ill. I don't believe he made any attempt to flee. I believe he went home. I would ask that Mr. Garreau be given a PR bond on this bond violation, Your Honor, and allowed to report for the next pretrial.
Okay, so
And
he was
receive his
serving
medical treatment as warranted. I don't think he's in any position to serve the rest of this sentence at this time.
I would rely on the history of the file for the reasons that Mr. Garreau is serving a 60-day sentence, and the court made an accommodation for Mr. Garreau to leave the jail for the sake of receiving medical treatment on the condition that he report back to jail when he was done receiving medical treatment. And regardless of what happens with respect to this warrant, Mr. Garreau has the remainder of his contempt sentence to serve. And the history in this case of Mr. Garreau not being truthful about his health conditions, I think speaks for itself. And so I'm not willing to accept anyone's word for where Mr. Garreau has been and whether or not he has been in the hospital until I see documentation of it. And so for those reasons, I would deny the request to modify bond.
Thank you, Your Honor. We will.
And Judge, to date, I have
attempt
not received
to do
any
the proper
additional-
releases and get that information.
All right.
And Judge, to date, I have not received any documentation as requested several times.
All right. Mr. Garreau, you can let the officer with you know that you're done with court for today.
Yeah.
Mr. Garreau?
Yeah.
If your wife has that documentation, she needs to provide it to myself and Mr. Coast.
Okay, Bob, you got a pen on you? I can have you call her. Yeah, I can call and send it to you.
Mr. Coast has that information, Ms. Underwood. I don't want him to do it because we're still broadcasting on YouTube. If you need that, if you need Mr. Garreau's wife's information or phone number, you can get that from Mr. Coast.
Thank you.
All right, this is file 24-52282-DO, Rachel Lynn Cardis versus Christos Cardis. We are here today for a divorce trial in this case, and we are proceeding today in person. First, going to have the attorneys place their appearances on the record, beginning with Ms. Wagner.
Good morning, Your Honor. Amanda Wagner appearing on behalf of and with the plaintiff, Rachel Cardis.
Good morning, Your Honor. Brian Fry appearing for defendant Christos Cardis.
All right, and thank you for your patience. Apologize for the delay in getting started. Are we ready to proceed?
Your Honor, I have a request that I'd like to make of the court. I don't know if now is the appropriate time to do that.
Okay, what is that?
So Your Honor, as much as I do not want to do this, I am going to request of the